Hi, my name is Anthony Ferrantina, and today I will be briefly touching upon a very famous and influential court case involving libel, free speech, and two other significant court cases. This case is known as Time Inc. versus Firestone. In 1975, Mary Alice Firestone, third wife of Russell A. Firestone Jr., owner of the Firestone Tire and Rubber Company, filed for divorce from her husband. Upon hearing this news, Russell Firestone Jr. filed a counterclaim against his wife, accusing her of extreme cruelty and adultery. The case went to the courts, with the judge finalizing the divorce, but discrediting both the claims of extreme cruelty and adultery. However, Time magazine, owned by Time Inc., published an article soon after the proceedings, bringing up the discredited allegations as not so false. A quote from the Time magazine article reads as, "Divorced by Russell A. Firestone Jr., 41, heir to the tire fortune, Mary Alice Sullivan, Firestone, 32, his third wife, a one-time Palm Beach school teacher on the grounds of extreme cruelty and adultery. After 6 years of marriage, one son, in West Palm Beach, Florida, the 17-month intermittent trial produced enough testimony of extramarital adventures on both sides," said the judge, "to make Dr. Freud's hair curl." Mary Alice, upon reading the article, sued Time Inc. for $100,000 in libel damages. Now, Time Inc. fell back on a libel case from 1964 in their defense, New York Times versus Sullivan, in which the Supreme Court ruled on the term of actual malice, which is the knowledge that the information being published was false, or a reckless disregard of whether the information was false or not was known before or during publication. And because of the difficulty of proving the burden of proof, which is the defendant's knowledge and intentions at the time, many cases involving public figures do not work out because they are public figures and have they're public figures and have to prove that the magazine publisher was in fact using actual malice because they're public. So Time Inc. stated that Mary was in fact a public figure because of her husband's company and could not seek damages without proving actual malice. Again, a very difficult thing to do. And in most cases, the courts tend to side with the publishers rather than the defendant. However, Mary Alice's attorney argued that she was in fact not a public figure by the standards set in a more recent, at the time, 1964 court case, Gertz versus Robert Welsh Inc., Incorporated, in which states are free to establish their own standards of liability for defamatory statements made about private individuals, and that if the state's standard is lower than actual malice, the standard applying to public figures, then only actual damages may be awarded. It was argued that Mary Alice Firestone was not a public figure because she had no special prominence in social settings and did not put herself into the limelight during the controversy to significantly influence its situation. So basically the court said that she was not a public figure and therefore Time Inc. lost the case. As such, the Supreme Court upheld the Florida Supreme Court decision in a 5-3 vote, and Mary Alice was given her $100,000 in damages. So this case is both important to communication as much as it's important to anyone working in the media field because it serves as a reminder that even if the Supreme Court tends to rule in favor of the media most of the time, especially in libelous cases involving public figures, it can still backfire, and that while free speech may be protected, it is important to understand the significance of defamation and how easily a good article can be ruined without appropriate fact-checking. Again, this is Anthony Ferrantino. Thank you for your time.